So now that we've got a bit of background about the facts of the SCO case and the basics of intellectual property law, we're in a better position to assess the vulnerabilities of the Linux kernel and other open source software to attack by companies like SCO. And some of the issues that arise out of the facts of the IBM case in particular are these. When are you allowed to copy? Okay, I've indicated already that there's several cases in which you are allowed to copy stuff. One of them is if the software has entered the public domain. This will happen automatically when the copyright expires, although, like I've said, that's quite a long time. It's like 50 years, and it's 70 years in America, but 50 years here. You can place software into the public domain deliberately if you sort of abandon your copyright or if you specifically license it into the public domain. So that has happened, and of course the whole open source movement to some extent relies on public domain software. The other instance in which you can copy software is when the copying isn't a substantial part. Now this phrase substantial part is something that lawyers make lots of money out of. It's got a qualitative and a quantitative meaning, so that, in other words, a small but vital fragment of code might be protected by copyright, whereas a longer but less important section of code might not be. So if you want to copy something and you're saying that it's not a substantial part, it's good to have a strong knowledge of the legal background to that phrase, or get legal advice from a lawyer about it, because it's grey area. The other thing you can do, as I've mentioned, is where there's a trivial copying, where you're copying something that is so trivial that there's only one way to write it. So like, for example, a Hello World program or script, there's only really one way you can write that, and so you can copy that. It doesn't even fall subject to copyright law. And that would apply to comments as well, code or comments, because they're not treated as a literary work if they're just trivial. And they probably wouldn't enjoy trade secret protection either if they're trivial, subject to, unless you've actually specifically agreed in a contract that you were going to protect these trivial secrets. Okay, another instance in which you can copy is where the copying is non-literal. So if there's nothing to prevent you from re-engineering the functionality of a copyright program, at least there's nothing in copyright law to prevent you from doing so. There may be something in patent law that does, but yeah, re-engineering is fine. And of course that's what the GNU project was all about originally, just creating a Unix that was better, that was not Unix, that was better than Unix. And in Australia you've also got the benefit of a provision of the Copyright Act which allows you to copy, including decompilation and reverse engineering, if you want to create an interoperable product. So if that's what you're specifically doing, if you're wanting to create an interoperable program, then you're allowed to copy the original program for that purpose. That's in Australia only. Now, it's sort of difficult to say whether, if there has been copying into the Linux kernel, whether it would fall into any of these categories. There's probably a good chance that it does. I mean, if it's something like the PowerPoint slides that we've seen, it probably does fall into one or more of these categories. We can't rule that out, but we can't rule it in. We don't really know enough yet. We might know more on the 23rd of January. Excuse me. Okay. So that's when you are allowed to copy, but on the other hand, the fact that you didn't copy any code doesn't necessarily clear you. I mean, you can commit a breach of intellectual property rights without copying any code, and there's three cases that I'm going to go through in which you can still be liable for code that you have written yourself. The first one is if a trade secret covers the code. In IBM's case, the fact that it was working on two Unix-like operating systems at the same time, that was always a danger. I mean, it wasn't a danger that IBM ignored. They knew about it and they took steps to deal with it. But for smaller developers, it can be difficult to protect yourself from being infected by confidential information if you're trying to work on two projects at once. So trade secrets are a difficulty. Likewise, patents. If the technology's been patented, it's even more difficult because you don't have to knowingly take on a duty of confidence. It can apply to you whether or not you know about the patent existing. You have to honour patents that you may not have even heard of. And the third one is if you create a derivative work of someone else's software. Now this normally, you might think a derivative work is something like a patch or a fork of some code. but it actually goes beyond that. It can include something like a library that plugs into someone else's code, or a plugin or something like that. That can still be a derivative work. And this is a really grey area, and I haven't got a slide about this, but I'd just like to go into a bit more on this whole notion of derivative works. The question of what is and what isn't a derivative work is probably the biggest unanswered question that we have in copyright law of computer software. There isn't a clear dividing line. It's in other cases, like when you're creating an adaptation of a play or a song or a movie or a translation or a abridgment or something like that, it's clear what is and what isn't a derivative work, but less so with software. And there's a couple of extremes. The Free Software Foundation is at one extreme, and they'll say that you create a derivative work of GPL code simply by linking to that code, even if the linking is dynamic rather than static. In other words, the GPL code is accessed at runtime from a separate library file. They say that's still creating a derivative work. So that's one extreme. The other extreme is to say that neither static nor dynamic linking creates derivative work because the original code isn't actually being touched. It's not actually making any modifications to that when it's just referenced or accessed through an API or something. So there's no derivative work created. And the true position, we don't know, but it's probably somewhere in between. Probably a program that dynamically links to a library doesn't, in my opinion, doesn't create a derivative work of that library. But on the other hand, a program that, that's right. If it statically links in, it probably does. But if it just interfaces with or interoperates with the software using an API or some higher level interface, particularly a higher level interface, then it's probably not going to be creating a derivative work for purposes of copyright law. But this is, like I say, it's a grey area. Recently, Linus has been talking about this last month on the kernel mailing list. Someone asked, okay, what about kernel modules? Are binary-only kernel modules okay? Presumably they are, because there's lots of them around. And he said, well, in my opinion, it sort of depends on whether the module plays with fundamental Linux behaviour. If it plays with fundamental Linux behaviour, then it is derivative. If it doesn't, then, and if it is derivative, of course, you can't have a binary-only module because the kernel is under GPL. But if it doesn't play with fundamental Linux behaviour, then it's fine, you can have a binary-only module. And Linus may well be right. We just really don't know, though, because the question hasn't been considered by a court. But I think he's on the right track anyway. I think it's probably something like that. Anyway, relating this back to the SCO case, IBM developed a whole bunch of stuff that extended the original Unix code in AIX, and so did that or did that not create a derived or a derivative work? And in the case of something like JFS, which I alluded to earlier, which is a journaling file system that IBM created, I think that that's pretty clearly not a derivative work because, well, for starters, the version that was ported over to Linux was actually developed by IBM for OS/2. Admittedly, they did also create an earlier version for AIX, but it's kind of independent of the operating system. I mean, it's a file system. It's not part of the operating system in the same way as even a kernel module would be. So I think to call that a derived work is a bit of a stretch. Yes? Yeah, that's the other thing. Sometimes SCO or others will say, oh look, this is our trade secret, but in fact you've got to look at, is it their trade secret or did they get it from someone else? Because they can only protect their own secrets. They can't protect other people's secrets. You know, that's for the other people to protect. So, and particularly if they weren't secret at all. If they were in the public domain, then there's no question of it being a trade secret, because that destroys a trade secret if it's been in the public domain.